Welcome to ESCA Legal Lounge. My name is Kimber Marie. I am one of the associates here at ESCA, and I'm joined today by another associate, Madison Marino. Madison, how are you today?
Hey, I'm good. I'm good. Just, getting things done.
We're almost to the end of the week. I know it's
Yeah,
been it's been a crazy week.
I had to think about what day it was for a second. I almost said happy Wednesday and it's Thursday, right?
I think so. It does feel like a Wednesday, so you're not
Okay.
alone on that.
I never
Um,
know.
I'm excited to be talking with you today because we're going to be going over trademarks and the most common questions that you get with clients or potential clients on discovery calls. And so I know a lot of people are constantly asking you about these. So we're just going to dive right in. For people who are just starting out, they're interested in filing and starting to protect their intellectual property, mainly trademarks. Is it better to file early when they're just starting out or later?
Always early. That's my default answer to this question. And sometimes, people don't have the benefit of filing early. They've already started and they have no choice. But as soon as you realize and know that a trademark is important to you in your business, that's when you file. You don't want to sit on it for too long. But if you are in a spot where you're just starting out, you're kind of just even at the conception stage where you know you are going to launch a product or a service and you know what the name's going to be or what the brand's going to be. At that point is when you can go ahead and file a trademark. The earlier, the better.
And would you say that it maybe, of course, everything depends, right? But
Right.
would your advice change a little for someone who may be launching a tangible product versus someone with a service?
I don't think so. I think, if you let's say are going to start an event planning business and you want to call it, I don't know, Kimber Marie Events. Like that's the brand.
Yeah.
Um, you can file a trademark application with that trademark for event planning as intent to use and then secure your spot in line so that, if someone else were to file Kimber Marie Events for the same type of services, you actually filed ahead of them and they can't block you from getting your trademark. So even if you haven't started and you're at a point where you're still brainstorming and but this is what you want to do, that's why I recommend filing early. So secure your spot in line. It wouldn't change though, based on services or goods. It's the same concept. If you know it's what you're going to do, you have the name, file.
Gotcha. That's super helpful. And it leads me to my next question, because I know you get this a lot. Is having an LLC registration or a domain name registration, is that enough? Like if you have those, do you even need a trademark?
Yeah, you do. You need a trademark. And the reason is because they're entirely different things. Just like an LLC is not the same as a domain, a trademark is a completely different asset to have, right? So your LLC is the name of your business. Your domain is how people are going to find you online. And your trademark is how people are going to identify you in the marketplace. So your LLC name could be the same as your trademark, but it doesn't have to be because your trademark is really an identifier for you and your brand as the provider of a product or service. And so it's great if you have the LLC and you have the domain, but you are missing that last piece, which is a trademark.
Awesome. And this also segues really well into the third question because sometimes people, they may have a different LLC than their trademark and they may have a logo plus a word mark. So
Mhm.
can you speak to whether people should file just the words, just the logo, or both?
So sorry, it depends. That's not the best answer, but the reason it depends is because depending on what's out there and even just what your brand is, what your trademark is, and what the logo looks like, it's really going to depend on what's already registered, what people are already using, and also what you're going to use, right? So the word mark is going to give you the broadest protection. It'll give you the broadest protection over any logo variation, whereas a logo is going to give you protection just of that specific logo design. And so the types of rights you get are just a little bit different. It's ideal to have both, register as many assets as you can so that you're protected across the board. But again, it'll depend if you can even have both. And that's why we typically recommend at that point if you've got a couple different assets to work with an attorney so that they can do a search for you and advise you on whether or not it's even something that you can get the word mark versus the logo.
Awesome. And I
Yeah.
do have a final follow-up question. This might
Okay.
be a little bit of a curveball, but can you speak to, so whenever you meet someone who's early stage of business and they're interested in protecting their intellectual property, specifically trademarks, and you're talking about what we do here at ESCA Legal, can you kind of just briefly go over the timeline? Like from like, would they schedule a discovery call? Would you go right into the engagement? Just kind of give a brief outline as to what that looks like for people who might be interested in reaching out to us.
Yeah, so I mean, a discovery call is a great idea. If you're not quite sure if you're ready to jump right in, you can definitely schedule a call and you'll probably get me on the other end of that line. And I can walk you through the process and answer any questions you have. But if you're ready to dive right in, you've got your trademark, you know what you're doing, and you're ready to go. And, if you have a couple questions, that's fine. But if you're ready to go, then at that point is when we'll engage you as a client and then dive right into a preliminary search. Make sure you're, free and clear to use. We'll advise you on like if the word mark is something that you can do, maybe a logo might be a better option depending on the results that we get and our analysis and the risks. Then we'll file for you. And at that point, we're getting into, the whole trademark prosecution process. After you file a trademark application, the USPTO will examine it, make sure it meets all of the requirements. And if it doesn't, they might ask you to fix it. And that's an office action. So that takes about, I don't know, 6 months after you file, let's say.
Yeah.
So you might not see a registration until a year. But at that point, like that's the USPTO's process, and we just kind of manage it for our clients and again, answer any questions, help them out how we can, and really just act kind of like a partner in that process. Try to ease the burden as much as possible because it's quite the process. But yeah, that's pretty much it, I think, I mean, in a
Yeah.
nutshell, without getting too into the weeds about everything.
For sure. That's great. And I think that really clears up people often looking for lawyers. They may feel intimidated and not know what to expect. So when it comes to what we do here at ESCA Legal with trademarks, I think that's very helpful. That was the only question or the last four questions I had for you today. So thank you for your time. And for our viewers, we will be back next week with another ESCA Legal team member, but we'll make that a surprise. You can catch us on YouTube, LinkedIn, and Instagram. Thank you, Madison. Also,
Thanks.
Madison has an Instagram. We got to plug that as well.
Oh.
Remind me, I think your handle is at Madison Esquire, correct?
It's at madison.esq. So that's how you can
Perfect.
find me. Yeah.
Awesome. Thank you, Madison.
Thank you. See you later.
Bye.
Bye.